Now, before I begin, can you see a title slide with the title, The Status of Non-Citizen Indigenous Australians? All right, then. Well, in that case, we should rock and roll. Before I begin, however, please, I'll say hello to everybody and hope that you're safe and well, considering the circumstances. The topic, the status of non-citizen Indigenous Australians under the Australian Constitution. I admit it's a very esoteric topic, but it's a topic which is of really very great significance and interest to the general Australian political community. So let's have a look at it. You should be asking, well, how did you land on the topic? And the answer is that it has come up in two fairly recent High Court cases. Just to let you know, the High Court of Australia, the court that I will be talking about for the next 15 minutes or so, is the apex court in the Australian legal system. It's similar to the American Supreme Court in that it hears all cases, not only constitutional cases, but of course the constitutional cases are some of the most interesting. I'm going to go through the two cases, Love and the Commonwealth and Thoms and the Commonwealth. I'm going to tell you about the issues, I'm going to tell you about the decision, and then we'll go through the reasoning and hopefully we can discuss some of the broader impacts of the decision during the question time. To make sense of the reasoning and the decision, you need to know some of the facts. So let's begin. Two cases heard together. The reason why they were heard together is because the facts of the two cases are very, very similar. You have two plaintiffs. I'm going to use the traditional Australian legal terminology here. Plaintiffs, you can think in your mind, equals a claimant or an applicant. So the two plaintiffs are not Australian citizens, but they are long-term residents and they do have their own families in Australia. The first plaintiff you can see on the left there, that is Mr. Thoms. He is a New Zealander. I think Mr. Thoms lived in New Zealand until he was about 4 years of age. He moved to Australia. He has lived in Australia for another 20, 25 years or so. So you would say he is an Australian resident. The gentleman on the right, that is Mr. Love. He is a citizen of Papua New Guinea. Similarly, he moved to Australia at a fairly young age. I can't quite remember. I think he was even younger, about 3 years of age. And he has basically lived in Australia since that time and has his own family. Both of the plaintiffs are Indigenous Australians. That becomes very important later, and we can talk about it. What really starts the case is this. Both of the plaintiffs were convicted of domestic violence offences. Mr. Thoms on the left, he was sentenced to 18 months in prison, and Mr. Love on the right, he was sentenced to 12 months in prison. Why am I making such a big deal out of the prison time? Here's the answer. If you are not an Australian citizen and you are sentenced to a prison term of 12 months or more, when you are released, you will almost certainly be deported from the country pursuant to an order under the Migration Act. Okay? So both of them, because of the fact that they were sentenced to these prison terms, they were liable to be deported, and indeed, the Minister for Home Affairs did issue orders revoking their residence permits, effectively meaning they were to be deported. I think for understandable reasons, they didn't want this to happen. They obviously spoke to their lawyers, and their lawyers thought about, well, let's talk about a constitutional challenge. Now, for many of you, a constitutional challenge will make intuitively good sense. I think particularly in Europe, whenever you want to challenge a government measure, you go to your constitutional rights. Here is a hard reality about the Australian Constitution. It's a functional document. It doesn't contain a whole bevy of rights. It does not contain a Bill of Rights. There are a few rights in there, but for the most part, this is a functional document that lays down the rules on how the various governments in Australia can exercise their powers. So, in light of that, this is what the plaintiffs did. They looked at Section 51 of the Australian Constitution. Why? Because Section 51 lists the legislative powers of the federal parliament. There is one such power under Section 51. It is the power for naturalisation and aliens. Why we're talking about naturalisation and aliens? Because the Migration Act is made pursuant to the aliens' power. Now remember, the Migration Act is the piece of legislation under which the minister ordered the two plaintiffs to be deported from Australia. So hopefully you can see what they're trying to do here. The plaintiffs are going to say, we are not aliens under the Australian Constitution, therefore any piece of legislation made pursuant to the Aliens Act cannot apply to us. Obviously, the Migration Act doesn't apply to us. If the Migration Act doesn't apply to us, the orders for our deportation are not valid. So that's the argument there. That's the issue. Is Love or Thoms an alien under the Australian Constitution? The decision is no, by a very, very thin majority, 4-3. And interestingly, the Chief Justice of the High Court of Australia was in the minority in this case, which is, I mean, it's always possible, but it's normally a rare occurrence. What does this decision mean practically? The orders were, Mr. Love, he already had his residence permit, the revocation of the residence permit, rather, it was already cancelled, meaning that the benefit of this decision doesn't quite have the same meaning compared to Mr. Thoms, who, after Mr. Thoms served his time in prison, he had to go to immigration detention, which is fairly similar to a prison. He stayed there for about 500 days until the High Court handed down the decision and the revocation of his residence permit was cancelled. So that's the outcome there. We need to understand the reasoning, though. I'm going to start with the reasoning of the three minority judges because their reasoning is actually fairly straightforward. First reason is this. The case law on the Australian Constitution establishes that a person who, I mean, let me put it in these simple terms, sorry, because I lost my train of thought. Citizenship determines whether a person is an alien or not. So if you are a non-citizen of Australia, then you are an alien. Now, the minority judges said this: we recognise that if we define the word alien to mean non-citizen, and the meaning of the word non-citizen is something that the parliament can decide, then it's really the parliament that's deciding the meaning of the word alien in the Constitution. And the minority judges said, yes, we're entirely comfortable with that. The only thing that the High Court should do is somehow maintain some type of supervisory control on the meaning of the word alien, to make sure that the federal parliament doesn't say that anything in this world is an alien. Second reason, the plaintiffs are non-citizens, which entails the easy conclusion: the plaintiffs are aliens and therefore they are subject to the Migration Act. That's the fairly conventional way of, I think, of looking at this case. Let's look at the majority judges, because I think the reasoning is a little bit more interesting. They, of course, have a very different view of the matter. Before I get into their reasons, I think it makes sense to lay down some foundations that the majority judges built their reasoning on. The first one is this: they do admit that the case law says a non-citizen equals an alien. And they also recognise that the Parliament then is going to then define the word alien. But, and this is the important part, the High Court also has a role in defining the word alien, which is actually very similar to what the minority judges said, but there's a difference in emphasis here. So with the minority judges, what they were saying was that we are going to supervise the Parliament. If you look at the majority judges, what they are saying is we also have a role in defining the word alien. Next foundation. The majority judges say there is no case law binding on the court in this case, which is a little bit inconsistent with what we heard earlier, because I told you that the minority judges said there's a rule that a non-citizen has to be an alien. The two plaintiffs in this case are non-citizens. Therefore, you'd think that their case fits within the boundaries of the precedent. The minority judges said no. What was the distinguishing factor in their opinion? The fact that the two plaintiffs were Indigenous Australians. This brought them outside the precedent. So the question now becomes this one here: are non-citizen Indigenous Australians aliens under the Australian Constitution? The majority judges say, in their first reason, well, I mean, they're going to say Indigenous Australians are not aliens. They give three reasons for this. The first one is this: if we tell Indigenous Australians that they are aliens under the Australian Constitution, that is inconsistent with their rights under Australian law with regard to their we call it native title or their land, in the land of Indigenous Australians. So you can see how that argument's going to work, because if you are an alien, you are subject to deportation. You can't enjoy your land rights if you're outside of the country. So that's reason number one. Reason number two is this: some of the judges looked at the debates for the drafting of the Australian Constitution, and they were quite it's quite an enlightening read, actually. Sometimes I have to pause and think how incredibly racist they were. They spoke very openly about the issue of race, and one thing that does come through in the debates is that an Indigenous Australian cannot be an alien under the Australian Constitution. So that's a little bit more of a originalist approach to the issue. Third reason, and I think this is the most important one out of all of them, the majority judges said there is a sense of belonging to the land that Indigenous Australians have that other people do not. So how did they get to this? Well, how did they build the proof for this reason? They said that in our role as the interpreters of the Constitution, we have to first understand the ordinary meaning of the word alien. The ordinary meaning of the word alien is this: someone who does not belong. So they said, okay, we can accept that. What does it mean to belong to something? And they said, well, you can belong to a group of people, the political community, or you can belong to the land. And considering that Indigenous Australians have lived in Australia for at least 40,000 years, they said there was such a deep and embedded connection between Indigenous Australians and the land, which meant that Indigenous Australians could not be aliens under the Australian Constitution. The second premise was to work out whether the plaintiffs were, in fact, Indigenous Australians. And they put together a three-part test for this here. First thing they said, you need to look at the biological descent of the person who is claiming to be an Indigenous Australian. In the case of Mr. Love, I think two or three of his great-grandparents were Indigenous Australians. Mr. Thoms, his great-great-great-grandmother was an Indigenous Australian. So on account of these factors, they were able to tick that box. Pardon me. Second point there, you need to self-identify as an Indigenous Australian, which is obviously not too difficult. And third one, you need to be recognised by a tribal elder of a recognised Indigenous tribe as part of that tribe. Now, Mr. Thoms was able to tick all three. Mr. Love, however, they put a question mark on the third one and they asked another court to decide it. But I think effectively the decision will be that both of the plaintiffs are Indigenous Australians. Indigenous Australians are not aliens, therefore that explains the decision. When the decision came down, I was in Australia at the time, I think, or I was in New Zealand. Put it this way, it made the news, and I want to give you a small sense of the reaction before I finish up. First thing, counsel for the plaintiffs, after the court handed down the decision, went to the media and said, the first thing we will be doing is filing for compensation for both of the both of the plaintiffs, because they spent time in a immigration detention centre, so their cause of action will be false imprisonment. And I actually saw that one of the plaintiffs has recently filed his claim. Next person I want to talk about is the Minister for Home Affairs, Mr. Peter Dutton. Now, I'm going to try and activate a little bit of technology here. I have a small snippet of an interview that Mr. Dutton did after the decision came down. It's about 1 minute in length. Whether this actually works or not, though, I don't know. I'll look on the side here, and if I have some looks that are saying to me this is not working, then I'll cut it off. And hopefully I won't see those looks. So let's try.
Most people are perplexed, including the Chief Justice, it appears, of the High Court about this decision by majority 4-3. That Indigenous people with connections to community and country can't be deported, even if they're non-citizens, even if they weren't born here. This is a legal minefield. And no doubt you've been taking advice since the decision was handed down. There's an impact on one particular person who must be released. Another person, they couldn't determine whether he was Indigenous or not. It's going to the federal court. Where do you go as a government with this decision?
Ray, I'm with the Chief Justice. This is a decision of the High Court, obviously, and as people know, it was 4-3, so it was a fairly split decision, and the Chief Justice, I think, has made some very good points, but it's a 170-page judgment, and I think the Attorney General, our General Counsel within Home Affairs, having a look at it, obviously, at the moment. I think there's significant repercussions, and essentially it creates another class of people, which I think is a very bad thing. So obviously we've got to adhere to the law, and they've interpreted the Constitution, but for us it makes it harder. and there may be other areas, particularly around citizenship.
All right, then. So that gives you some sense of what the minister was saying. There was an idea. I mean, the line from the government was, now there are two classes of citizens under the Australian Constitution. I also, of course, want to give you the other side of the debate. And I picked out a quote from Marcia Langton. She's the Professor for Australian Indigenous Studies at the University of Melbourne. I wasn't going to take the whole article and throw it on you. I just thought I'd take out her conclusion, and it was this: Australians should feel pride in our common law because it is logical and just. And I thought that might be a good point to stop on, even though I desperately want to hear your thoughts and also give my thoughts on the reasonings. But I'll leave that part for the question and answer session. So thank you very much for your attention.